Right. Hello, everyone, and welcome to this last panel of the day, Teaching Commercial Law in the 21st Century. I want to thank Matt Bruckner for putting this together and our three co-sponsoring organizations, the section on commercial and consumer law, teaching methods and technology, and law and legal education. So you can imagine from those sponsoring organizations and the breadth of the title, we have a lot of ground to cover today. So we've arranged for this to be more of an informal discussion between the panelists. I'll be keeping an eye on the chat. It looks like I can see the chat, so that's, step one. And I welcome your questions and comments as we go through this. So let me introduce our panelists. We've got first Carlos Chapman. She is an associate professor at Washington and Lee University School of Law. She teaches an array of corporate commercial law and transactional skills courses, and her scholarship focuses on personhood, corporate governance, and ethics. Bill Henning is a professor at Texas A&M University School of Law. He teaches contracts, sales and leases, and secured transactions. And he's a former executive director and current life member of the Uniform Law Commission, a member of the American Law Institute, and an emeritus member of the Permanent Editorial Board for the UCC. John McGarvey taught secured transactions for 16 years as an adjunct professor at the University of Kentucky Rosenberg College of Law and the University of Louisville. Did I say that right? I know there's a Louisville kind of there. Okay, good. Brandeis School of Law. He's the chairperson of the Uniform Law Commission's UCC committee, an ex officio member of the Permanent Editorial Board for the UCC, and a member of the American Law Institute. He focuses his practice on commercial law at the law firm of Morgan, Pottinger, McGarvey in Louisville and Lexington, Kentucky. And I'm Kara Bruce. I teach bankruptcy and commercial law at the University of Toledo College of Law. And this semester I'm visiting at Loyola University of Chicago. So teaching law in the 21st century, teaching commercial law in the 21st century is a broad topic. And we thought it fitting to start with outcomes by looking to the trenches of law practice to see what's going on there. So John, I'd love for you to start. Can you describe the current state of commercial law practice?
Well, unfortunately, the words that come to mind are spotty, weak, insufficient. As examples of that, I'll give you two that have transpired recently just in my life. Yesterday, I had one of the best bankruptcy practitioners I know, partner in a big name firm, call me and said, I need your help. Can you help one of my clients? They need to structure an Article 9 sale. You're the only person I know who would know how to do it. Well, it's not because I'm not that bright, it's because other people haven't gotten up to speed on part 6 of Article 9, one of its most basic parts. Another example, not quite as recently, but I had one of the brightest students I ever taught, became a first-year associate at a large regional big name law firm. And she called me maybe 6 months into her practice to thank me for teaching her secure transactions, because she said, I'm the only one in the office that knows that area of law, and I've become the go-to person. I have partners coming to me all the time for advice. Again, not because I was a great teacher of commercial law, but because not that many people were taking it and getting the background. I'm afraid that too many law students take a course like secure transactions because there might be a question on the bar. One of the questions I always ask, or probably the opening question I ask my students every fall or spring semester, was, why did you take this class? And I'd get 4 or 5 answers that were kiss up answers. And then finally somebody would say, because there might be a question on the bar exam. I'd say, you get bonus points for the day because you're being honest with me. But I think there are a lot of students do that, but I think there are also a number of students that think, oh, that's no big deal. I'll learn that course in the bar review. It is beyond my comprehension that you could understand the law of secure transactions sufficiently to go out and practice, maybe to pass the bar exam, but not to practice by taking it in a bar review course. The best calls I get from students thinking about the bar exam are every 2 or 3 years when there is an Article 9 question on the exam, and they start calling the afternoon, late in the afternoon of the bar exam there was an Article 9 question and I aced it, or getting me to verify their answer. But to answer your question directly, I think the very reason we're having this program is that some of us, for some of the reasons we'll discuss in a little bit, have become concerned about the state of the teaching of commercial law in law schools today.
So Bill, that's a great transition to your work on the permanent editorial board. And I know you follow the case law in this area very closely. Can you tell us a little bit about some of these cases that have come down recently that are misinterpreting commercial law concepts and what you think we can do about it?
Yeah, this is an area that has worried me for some time, for quite a number of years. Ending about 4 years ago, I wrote for the Uniform Commercial Code Law Letter, and one of my standard techniques for finding something to write about was to go find a wrongly decided UCC case, and there are plenty of them out there. And you worry a little bit about the state of teaching of commercial law if the product we're getting out of the courts is so bad. But recently there have been and recently I mean 8-10 years, there have been a spate of really bad federal circuit court, or there's also, I'll make an aside mention of a New York Court of Appeals case. It's not going to be a main focus. It's not one that I mentioned to you when we were talking, Kara, that are so badly decided that the permanent editorial board either has published a commentary distinguishing and explaining how the case misapplies the UCC, or has draft PEB commentaries in the works right now. And these are just, I don't know how to describe them other than just boneheaded decisions.
We had two in 2019, Bill. I mean, that's one of the things that got our attention. We had 2 in 1 year.
Right. John and my participation in this panel springs out of conversations at the Uniform Law Commission's UCC committee and at the PEB about, if the state of commercial law is this bad, is there anything that can be done about it? How can we spread the word? But just taking a few of the cases, there's a 2013 Sixth Circuit case, First Source Bank, and I'm not going to read the citation. Kara, I think you're going to put the citations to my 3 main cases up on the chat for folks. But we all know that within Article 9, you have different types of collateral, and Article 9 uses the term type. And so you have accounts, you have chattel paper, goods is a type, you have subtypes, 4 subtypes within goods. Proceeds is a different concept. Proceeds are property that essentially replace the economic value of original collateral. But in the First Source case, the court concluded that accounts could not be proceeds from the sale, in that case, of equipment, not inventory, which is normally where you'd see accounts as proceeds. But accounts couldn't be proceeds because proceed is a type, and we all know that the types of collateral within Article 9 are mutually exclusive. So something that would fit within the definition of account couldn't be proceeds, and this is the Sixth Circuit Court of Appeals. And there is, again, a draft PEB commentary. When I say draft PEB commentary, I might mention that when these get pretty close to the point at which we want to publish them, they will be released to the ALI's members consultative group for comment and posted on the ALI and ULC websites. And there will be a 60-day period for us to receive comments and fine tune. And I hope people will take advantage of that. We really get a lot of very, very helpful feedback. So that's the First Source Bank case. One that caused John and I mean, this was a tilting at windmills mission, but John and I submitted an amicus brief to the U.S. Supreme Court urging it to take the case of I-80 equipment. That's a 2019 Seventh Circuit decision in which the Second Circuit concluded that I don't want to use the word description, indication of collateral, whatever term you want to use, the language that you use in the collateral box on a financing statement was adequate if you cross-referenced a security agreement.
Bill, something I want to do to defend us is we weren't so dumb as to think the Supreme Court would take review of a UCC case, but we wanted it out there. But we also had that division of circuits between the First and the Seventh in the In re Puerto Rican bondholders case.
Yes, thank you, John. And there is a decision that got that right in the. I don't think I have the site to that right now. If somebody wants to email me, I can email that back to them. But there's a First Circuit decision that found that a cross-reference to a document, even though it was online, wasn't easily findable, easily accessible, and didn't satisfy. So, you know, I think the I-80 has the capacity to really undermine the notice system. And then you have the Durham Capital Corporation case, and this is the subject of an existing PEB commentary number 21. In a couple of places, not often, within Article 9, we use the word assignor and assignee rather than secured party and debtor. And this is a sort of a holdover from old Section 9318 of the pre-2001 code. And I kind of regret that language was held over, but it's caused confusion. And in the Durham Capital Corporation case, the 11th Circuit held that the term assignment referred only to an outright sale of payment rights and did not refer to the use of those same payment rights as security for an existing obligation. And of course, security interest is broadly defined and includes both interests that secure an obligation and interests that in effect are ownership interests of buyers of payment rights in transactions within the scope of Article 9. So I'll let it go at this point. There are several others I mentioned. There's an existing PEB commentary 18. There was a New York Court of Appeals case called Highland Capital that basically said normal promissory notes are real in a series, not standalone. Promissory notes in a series are actually securities because they're capable of being recorded in a system maintained for the recordation, and they fit within the definition of security within Article 8, which just bollockses up lots of things. So there's just tons and tons of bad decisions, but it's really troubling to me and to John and I know a lot of others when you get major circuit courts and courts like the New York Court of Appeals making fundamental errors like that. Something seems to be wrong in the way we're transmitting commercial law. And maybe it starts in the law schools and maybe it doesn't, but it's a worrisome phenomenon, and I'm glad to get a chance to get it out there.
Thank you, Bill. So Carlos, let's bring you into this and also step back into the classroom. When you think about preparing all of our graduates, not just the students who realize they want to be commercial lawyers when they grow up, God bless them, but also those students who realize after they've graduated that, oh, wow, commerce happens to be, you know, one of those things that's everywhere. What do you think are the substantive knowledge and skills we should be using or giving to the next generation of lawyers?
Yeah, so, you know, I think it's interesting because I am one of those people who learned Article 9 in Barbary until I started practicing and had to do it. And now I teach it. So it's one of those things where I teach Articles, you know, 2, 3, 4, and 9, only took Article 2 in law school, and, you know, otherwise learned it in Barbary, learned it in practice. And, you know, one reason I love teaching commercial law is because I think we miss out on the fact that commercial law is a great tool for just teaching all fundamentals and even teaching jurisprudence. You know, as Bill and John were talking about cases that are wrongly decided, you know, if we look at the baseline of why cases get wrongly decided, you know, it's a lack of an understanding of statutes. It's a lack of an understanding of, you know, the history of something. It's a lack of the understanding of how private ordering works. And so if you take commercial law as a, as a vehicle to like reinforce the first year, which is what I do when I teach, the survey course. I think there are just so many fundamentals that are there. One is, again, as I said, how to interpret and apply statutes. Every UCC class, including first year contracts, has a deep dive into the code and a deep dive into statutory interpretation. There's the opportunity to be comparative if you're also teaching CISG. And if students aren't taking a statutory interpretation class in law school, I think our area, commercial law, and maybe like trust and estates and some others that get deep into statutes are the only other introduction. But I know so many of us find when we meet those people coming out of law school, they really don't know how to read a statute. And so UCC is their opportunity to do that. The other thing that I like to teach or emphasize, big fundamental when I teach commercial law, the proper weight of case law as compared to statutory language, as compared to the private ordering in the contracts. Every commercial law case is going to have some underlying agreement that is there. And I find when courts get it wrong, they don't give proper weight to the private ordering, or the court's not interpreting the statute correctly. So, I think I use those cases where judges get it wrong to then go break down how the judge either misread the statute or break down how the judge misread the contract, just to reinforce that. The other element, thing we should be teaching all the time, remedies. And all of the UCC classes give an opportunity. When we talk about warranties, we're being comparative about tort remedies versus contract remedies. We talk about equity and what is the underlying principle of the type of remedy that we are teaching in a UCC class. And, there's the opportunity that all students need that, whether they're, going into commercial law or not. I mentioned jurisprudence, legal history. First year contracts teaches 200-year-old cases. But then it also has the opportunity to teach technology cases and modern cases. So you can show the evolution of the law via commercial law. And I think it's important for students to understand how, when we develop new laws, when these, uniform law commissions and others are developing new laws, we're relying on the fundamentals of the past as a touchstone. And then lastly, the most important thing I think we can teach students is the importance of private ordering and how to work with private documents. What does it mean when you write an agreement that deviates from the defaults? What are you putting your clients into? What are they getting into? And so many commercial cases are contracts gone wrong. So many general corporate cases are contracts gone wrong. And, this is a great opportunity to show them boilerplate agreements versus self-written agreements and, show how they tweak and deviate from statutes and how you can draft around case law.
That was a great description of all of the different types of not just, fundamental black letter law, but also skills and ideas and ways of looking at the law that we need to be preparing our students with. And all of that takes time, which we don't have a lot of in these survey style courses. So I would love to hear from all of you. And why don't we start with you, Carlos, and then move backwards in reverse order. How do you, with limited time, prioritize? What are the things that you make sure to focus on, and what do you leave for those students who are going to practice in this area to pick up in their firms or whatever else?
I tend to focus on making sure I get the framework and hit the high points. With first year contracts, I want to make sure I cover every aspect of a contract. So from formation to interpretation, breach, remedies, third parties. As long as I hit all of those things, I'm not as nitpicky about getting in the weeds. I just want to make sure I give them a full picture of a contract, especially since we have a 4-hour contracts class. Maybe I can't get as into sales as I would like to in first year contracts, but if I've given them a good framework about, the basics of a contract, I feel okay, and just emphasize to them that 4 hours is not enough for contracts. I think everyone should have 6 hours of contracts, but we keep losing that battle.
We've got 6.
Yeah, when I teach the commercial law survey, unfortunately, I generally am guided by what's on the Virginia bar exam. Virginia is one of those states that still teaches Article 3 and 4. And so when I am teaching that section of the class, I don't talk about federal as much because it's not on the bar. And I recognize that my class is the only time they're going to see Article 3 and 4. So I probably spend more time on the state law stuff than the federal than I would if I were in a perfect world and I could just do a survey. But when I do, in addition to doing, just making sure I cover everything that's on the Virginia bar exam, since, it really is going to be the only time a lot of my students are going to see this stuff outside of first year contracts. I try to take time to cover at least one special thing each semester, if not multiple special things when I teach commercial law. I try to teach race and commercial law, either as a review session or folding it in, adding an element, to each unit. I fold in some contract drafting and document review. Sometimes it's a homework assignment and I say, okay, here's a clause, draft around 2207. Like, find a way to get around 2207. It's really, really hard. You probably can't do it, but that's the point. And we also do a lot of I call it document review. And that what I'll do is I'll pull a commercial agreement and have my students, find the clause that addresses X section of the code. And sometimes it's an in-class exercise, sometimes it's out of class, but I want to get them used to touching the commercial documents. I make a point of pulling documents that are bad, that are subject to litigation, to make sure that it's like, here's how these lawyers who make a whole lot more money than I do got this wrong. Let's find this mistake and unravel it. And then the other thing I make sure I always try to fold in is mentioning technology, whether it's, shrink wrap, click wrap cases, or talking about blockchain. I want them to understand that this is an area that's evolving yet misinterpreted. And so it's really, really important for them to get the fundamentals.
Absolutely. And Bill, that's a great transition to your focus. I know you've done a lot to weave in those developing technology ideas in your courses. So do you have some techniques that you've used to introduce students to new technologies?
Kara, did you call on me on that one?
I did. I did. You can pass though.
No, I'm not going to pass. I've got that in the back of my mind, but I thought that was in our next set of topics. So,
it is. I totally forgot. Do you want to talk about priorities first?
I thought I would take up basically the same topic that Carlos just spoke about a little bit. Embellish on that a little bit, if you don't mind.
Yes, of course.
I teach 3 courses in this area. I teach basic contracts, teach sales and leases and of goods, and secure transactions. And my approach to the courses couldn't really be different. They are 3 totally different courses from my perspective. And I've done them in different ways at different times in my career. And I would really like to get feedback, because I'm not sure that the choices I've ever made are the right choices. And I'm not sure the choices I've made today are the right choices. In contracts, I tell the students, not sort of kiddingly, but not really kiddingly, that teaching them contracts is not among my top 3 goals for the course. It's a first year course. We're learning to read language carefully. We're learning case analysis. We're developing a vocabulary together. They need to develop a perspective of lawyer as litigator, lawyer as counselor and planner, lawyer as risk manager, regulator. And we use examples and cases from the contracts area to explore all of those concepts. But I've made a different decision than Carlos. And again, I don't know whether this is right or wrong. I've decided to go more into depth and worry less about coverage. And I have certain areas where I've just put together handouts, like the statute of frauds, I only do the UCC statute of frauds, and I just talk a little bit about the others. And in my handout, I have a reference to the restatement provisions and the other areas within what you think of. It's kind of a oxymoron, but the common law statute of frauds. But I do the UCC. When I do misrepresentation, I have a handout, and we cover it quickly. But then, you know, when we get into the parole evidence rule and interpretation and lots of different areas in the course, I try to go as deeply into it as I can get with a first year class. And those are the ones that I think the students get the most out of. So I don't worry as much about coverage. And I frequently at the end of the semester will say, and I don't say it before the end of the semester, but I'll say, I don't think I gave you enough on this topic or that topic to want to put it on the final exam. I'm going to, you know, we studied it back when, but I'm not going to hold you responsible for it. In sales and leases, that's much more of a traditional UCC course for me. It's an extension of contracts. I get a little deeper into third-party beneficiary because the non-privity cases let you do that. It's a nice blend, I think, of case analysis, problem sets, I again use the CISG, probably more in sales than I do in contracts. But then I get to secured transactions, and I've just completely changed my approach over time. I teach a few of these cases. I have the students read a case now and then. But I've turned it into a almost totally statutory course. I give them textual background readings and then tell them that their text is the Uniform Commercial Code and the official comments. And then I've developed problem sets. And the problem sets have cross references to the code provisions, but they've got to put it together and they've got to go from here to here to here to here. We all know how you have to jump around within the code. And so it's problem analysis, problem analysis, problem analysis. You've done your case analysis elsewhere. You know, we're just going to do statute, 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 statute. And, you know, it's fine to talk to me about policy, but the drafters have set the policy, so good luck with that. I understand I'm describing a really conscribed small area. And again, I question myself all the time. Am I doing them a service or a disservice by doing it this way? But that's my current approach to it. And I worry a lot about secured transactions. Prior to 2001, you could almost teach the course, but since the expansion of the types of covered transactions, it's very hard to get it done. And I do worry more. I worry more about coverage in secured transactions than I do in contracts, oddly enough.
It's one of those classes where they have to get their hands dirty. So I think that's a great way of going about it. John, let's pull you in and talk about your priorities when you teach commercial law.
Well, first of all, I'm anxious to see Carlos's new show on MTV next season, Contracts Gone Wild. I like that term she used. I don't know of any student I've ever taught who looked forward to taking secured transactions. They dread it to some extent. And on the first day of class, I always try to set their expectations. And I tell them at the end of the semester, I don't expect them to know every section of Article 9. I tell them the exam's going to be an open book. As Bill says, the main text they're going to use is West Selected Commercial Statutes, happens to be the one I use. But instead of knowing an answer to a question, what I want to teach them is how to recognize the issue and how to find that rule within the sections of Article 9 that will give them the answer to the issue that they're considering. I tell them to remember the basic principle of the Uniform Commercial Code. Every article is to facilitate commerce. And the code does that by giving certainty to commercial transactions. That's why we have all these rules. I tell them the public policy of the drafters. Bill's been a drafter more often than I have. Bill and I worked together on the 2010 amendments to Article 9. But the public policy there is the drafters generally write rules to protect the party least able to protect itself. One of the things I tell them to do when addressing an Article 9 question is always classify the collateral. And it's the first thing to do when anytime an Article 9 issue comes up. Is that bulldozer equipment? Is it inventory? Because depending on how you classify the collateral, a different set of rules is going to apply. And that's what I'm trying to teach them, is how to find the rule. Usually I put up first day reading assignments for a class. And one of the cases I typically assign is one that turned on, was the certificate of deposit an instrument or was it a deposit account? Just as an example of why it's so important to classify the collateral in any given situation. But I tell them if they just know how to navigate the rules and which rule to apply, such as by classifying the collateral, they're going to end up being a valuable attorney at their law firm and their in-house law department, because they're going to be that one person that I talked about earlier, the student that called me, that really knows this area of the law, and suddenly they're going to have a great deal of value to the law firm or the corporation for which they're working.
And that's good job security. I like that.
Yes.
So Bill, let's revisit that idea of emerging technologies now that I'm not ahead of myself. So what techniques do you use to get students exposed to developing technologies in these kind of basic survey style courses?
Yeah, that is a great question, and it's something we have to do more and more. And I have had the good fortune to be on the current drafting committee on the UCC and emerging technologies, and I'm what's called division chair within the ULC. We have a committee on technology that advises our drafting committees on technology issues. And having immersed myself in this stuff, I don't understand it a bit. I mean, it mystifies me. You want me to describe blockchain or distributed ledger technology? Good luck. But I think there are ways to get at technological issues that fit within the ways in which we normally deal with issues in the classroom. The first thing, I think, foundationally, is the students just have to be grounded in the Uniform Electronic Transactions Act and the federal digital signatures in global and national commerce, the e-sign legislation. Yeah. And I have a segment on that. I have one of the handouts that talks about that, and you know, it's really interesting when you drill down and realize it's one of these areas where the federal e-sign legislation has a reverse preemption provision. If the state has UEDA in roughly the form in which it was drafted by the ULC, that's actually the statute says in the form in which it was promulgated by the ULC, then the provisions of e-sign that overlap with UEDA are preempted and state law governs. And because UEDA itself is an opt-in, it's easy to opt in. It's easy to find that the parties have agreed. I hand out a card that has an email address. One of the examples in UEDA says that I've agreed to transact business by electronic means by doing that. But because it's an opt-in and because the federal law is precluded, there's a gap in there where you might not, where neither of the electronic contracting regimes applies. So that's kind of foundational. Gotta get them up to speed, get them using the terminology of record as opposed to writing and electronic document is fine, but when you start using document, you start overlapping into, is it an Article 9 document? So I want to use clarity of language. And then when you start talking, and I'll use one other example, and it's really important because it's a main focus of the current UCC drafting project with regard to emerging technologies. When you start talking about control in an Article 9 course, and right now I'm talking about electronic control as opposed to three-party control agreements. But if you look just at the definition of control in section 9105, I think it is, for electronic chattel paper, it really focuses on the reliability of the system and its ability to identify a person as the assignee of the chattel paper. And then there's sort of a safe harbor down below that, and the technology to comply with the safe harbor is really complicated, and I think has hindered the growth of the industry.
It creates that definition of single authoritative copy.
Yeah, has really created a problem. So as within the new project, we are going to be creating UCC electronic promissory notes, not the sort of small case electronic notes that are transferable records that don't have the full weight of the rules of Article 3. But we're going to be creating those. We're going to be creating rules for virtual currency. We're going to be creating rules for other digital assets. And we're giving a lot more thought to control. And here's how you can translate that into the classroom. If electronic control is supposed to be roughly the equivalent of physical possession, then think about what the attributes are of physical possession. Physical possession allows me, if I'm the possessor, to reap the benefit, or substantially all the benefit, of the asset I possess, to exclude someone else from reaping that benefit, and it gives me the power to transfer the benefit to someone else. So you can do a thought experiment, and you can say to a class, you know, you're going to create an electronic system that is going to be the equivalent of physical possession. Don't worry about the technology. The UCC needs to be technology neutral. We don't need to be blessing this technology or that technology. What is it that you want this to do? And the students can come up with those characteristics of possession. And then you can take a look at what we've drafted to date, what Steve Harris has brilliantly drafted to date. And there's a working group that's met every week for half a year to help inform in that regard. But basically it talks about these attributes, and then the part with regard to the system is the system still has to be able to tell you who owns, or not owns, but who is the person who has the control of the asset. So I think you bring technology in by relating it to other doctrines that they're familiar with, and causing them to think about what it is that permits you to walk from the physical world over into the virtual world. Sorry, that took longer than I meant.
No, it's great deep dives into these areas. I want to pause and see if anybody else wants to jump in on this idea of integrating new technologies. We good? Okay, Carlos, you mentioned earlier talking about, or weaving into your classes, issues of race. So I'd love to hear how you do this in a commercial law course, where the connection is not as obvious as it is in other law courses.
I do a lot of what I talk about with teaching jurisprudence and teaching history. There are definitions in the UCC of various types of persons, of person, and then there's definitions of property. And so, I teach a survey, so we're dealing with promissory notes, and we're dealing with drafts and other things. And slavery is actually a good resource to draw a parallel. So when I teach my commercial law survey course, I teach a capstone review session that is focused on my own institution that I call Slavery and Commercial Law. And I pull, the transaction of when Washington and Lee was gifted some slaves and sold some enslaved persons. I found some promissory notes that were issued to Robert E. Lee during the Civil War in the archives. And, I use it comparatively. I pulled the definition of person from the Virginia Code in the 1800s, and we compare it to the definition of person in the UCC. And I really just walk them through a simulation from the acquisition of the enslaved persons to the sale, folding in some hypotheticals where they're sold on credit, or, where W&L defaults on something and has used the enslaved persons as collateral, just to use it to review the entire course. This year I did it all in one day because of Zoom, but other semesters, I've broken it out into the individual parts. So when they acquire the slaves, I will put that in my sales section. When there's a promissory note and just the note itself, I will put that in my Article 3.4 section. And then when there's defaults, I put that in the Article 9 section of the course so that there's a overarching theme. But it works really well. And I actually think that the material helps them to solidify the concepts as well. It makes them deep dive into the statute. And, I discuss with them how, we are looking at concepts that predated the uniform laws, but look at how these concepts were discussed in the 1800s and then what has happened and what we have now in the UCC, and to draw the parallel and the comparison.
Seems like a great way to weave it through the arc of the course. Now, John, let's go back to you and think about what sort of professional skills types of exercises you bring into your courses. I know that's a big deal to you.
Well, I try not to make it a skills course because I want to teach them the basic fundamental public policy behind the law. And anytime we're talking about a specific section of law, we talk, what's the public policy? Why did the drafters do this? But I think you can bring this to life with examples. And beginning probably 2 or 3 weeks into my class, try not to make it something difficult, but I'll come in with what I call the real world question of the day. And it's one that I've gotten since the last time I saw them, or gotten within the past week or two, and say, okay, a client called me today or yesterday and asked me this. How do we find the answer? And I might spend 5-10 minutes letting him go through, well, what about this section? What about that section? But to bring it home as to the real world things they'll be dealing with. One of the things I always try to do during a class, and as an adjunct, I have the ability to do it. I'll send out an email to my law firm who needs to get a financing statement filed on something. And we'll actually bring up, because we have technology in the classroom now, we'll bring up the Kentucky Secretary of State's website, bring up the template that you have to complete, but not just do it, say, okay, here's the name of the debtor. How do we find what the right name of the debtor is? Oh, it's a registered organization. Okay, let's go over to the Secretary of State's organizational records in order to find that proper name. We'll talk about the secured party's name. We'll talk about a collateral description so you don't end up with a decision like in I-80 equipment. But it's a skill that I teach them. And one of the things I'll tell my students every semester is I will guarantee you there are going to be 2 questions on the final exam. There'll be one that relates to part 6 of Article 9, because it's my favorite part of Article 9. And I will give you a fact situation from which you have to properly complete a financing statement, because I don't want anybody coming out of one of my classes that doesn't know how to do that. But again, I don't try to make it all war stories. I don't try to do that every class, but I want to relate the deep concepts that Bill teaches so well to things they will encounter in the real world. To some extent, I think adjuncts can bring that to the table, which I did for the 16 years that I taught. On the other hand, I had a fellow member of the Permanent Editorial Board comment that one of the problems with teaching commercial law today is that too many law schools use adjuncts. And I just sat there and kept quiet at the time. But I think there's a good blend that either a professor can bring to the table, because there are plenty of cases out there with real world examples, or an adjunct who's willing to spend the time to go through the material to bring the deep dive understanding of the fundamental concepts, but then relate them to the real world issues that we deal with every day.
Great. Well, so let's focus on that idea of the use of adjuncts, and there are other ways that our institutions try to, allocate the scarce resources. Carlos is teaching a survey style course, so different areas of commercial law blended together to give more students exposure to different topics. At my institution, since Ohio has moved to the uniform bar, I don't think we've offered payment systems more than once. I may have the numbers off there. So cutting courses that are routinely offered on the bar exam is another thing we're dealing with. So I can lock this at Bill, but I'm curious if anybody has thoughts on these types of developments and how we balance our interest in preparing the next generation of commercial lawyers against these realities of the business of running law schools?
I'll start on that one. You know, my law school haven't taught payment systems since I was there, and I don't think the law school where I taught before taught payment systems. You know, I think it's a big loss, honestly. You know, payment systems is valuable for more than just the bar exam, as is Article 9 and sales. And, you know, it goes to the fundamental things I mentioned on the first question. You know, I think we graduate people who don't see enough contracts and who don't see enough, you know, documents that aren't litigation documents. And I think that happens because of how much emphasis all of our schools spend, you know, on bar exam instruction and dropping classes that, you know, yes, it was valuable because every bar exam, you know, back when I was in law school tested payment systems, but, you know, there were other things that you got out of a payment systems class other than what was on the bar.
Well, I think it's important because even though there are more payments made through ACH transactions than checks, we're still got who knows how many gazillion checks out there in the world. And I deal with check fraud cases every week. You learn that through payment systems. A city administrator called me. I've got this letter of credit in lieu of a surety bond for this contractor that didn't build the roads in the subdivision. What do I do with it? Well, that's Part 5, generally, at least in the courses I'm familiar with, comes into payment systems 3, 4, and 5. But yeah, there are all kinds of pieces that have absolute everyday application that are not being covered by law schools. One of the things I've heard discussed to some extent is what I call the U.S. News and World Report impact on teaching at law schools and the emphasis that's put on torts and constitutional law and classes like that, and making big name hires in those areas as opposed to hiring the Bill Hennings of the world who are experts in commercial law, just because they're more worried sometimes about how they're going to be rated in the next survey than they are in producing well-equipped law students.
Yeah, if I could jump in, let me start with an anecdote, if you don't mind. Back 2 or 3 centuries ago, when I was in law school, I started a negotiable instruments class and dropped it after the first week because after a week of it, I concluded that no human being rationally could understand that stuff, and I had to learn it in practice. I'm not concerned about adjuncts teaching the courses per se. I am very concerned about complete omissions like not having payment systems. I don't worry so much about parts of the UCC not being covered, but there are all kinds of fundamental issues. How are debts discharged? How are risks allocated that run across systems? And you can talk about those from Article 3 to Article 4 to Article 4A to Article 5 to credit card systems to debit card systems to, you know, to automated clearing and on and on and on.
And the code's essentially a set of loss allocation rules.
Right. So I worry about that omission, but here's what worries me about the move to have adjuncts teach the core commercial law courses to the exclusion of having full-time faculty members doing it. And that is, the institution itself loses track of what's important in terms of setting the curriculum.
Yeah.
You don't have people sitting in on faculty meetings, sitting on curriculum committees saying, now, wait a minute, you can't do that. Here's why this is important. So I think you need to have, full-time, regular faculty members who are thinking about the courses, who are researching the courses, who are teaching the courses. But a lot of this can and should be done through adjuncts like John. I mean, one kind of an aside, but John took the names off, but provided me with a fabulous, like 17 or 18 page security agreement that he developed for an automobile dealership. And when I'm teaching the Article 9 course and I have this problem set, and we'll be talking about future advance clauses or the ability to establish by contract standards to measure a commercially reasonable disposition should be conducted. I tell the students to go into that document and find where it's done in there. So I'm not teaching them to draft, but I'm using it as a vehicle. So I think adjuncts and the skill that John put into that are fabulous additions to the curriculum. But I really worry when law schools just divorce themselves from commercial law because they've got more important fish to fry.
I would like to add too that not only is commercial law not being taught in law school, the commercial law concepts that I learned in high school are not being taught. So I was shocked this year by the number of students who had no idea how to write a check, like totally clueless about it. And so, I think I learned.
But they know Venmo.
But they know Venmo, right? But steps in middle school or high school. And so when our classes are cut from the curriculum, we're also cutting basic life skills that our students need.
Good point.
Absolutely. So Martin in the audience wanted to ask a question on this general topic, if you guys are up for it. Martin, can we hear you? I'm a little bit nervous about this Zoom, this like not real Zoom situation. Okay, we heard we're not going to be able to hear him, so feel free to put it in the chat, Martin. Why don't we touch real briefly before we conclude and stop for questions in the chat about kind of as we're gearing up for the next semester, many of us are going to be teaching on the line. Our students are, and sometimes us, we are going through a lot in this new pandemic reality. So any ideas on how to reach students, how to adapt our courses in these difficult times? Anyone? Any good thing? Yeah.
I'll take a stab, but I don't think I'm doing anything particularly special. I'm teaching, our classes are being held in person. I'm behind a plexiglass screen, which is cleaned, and the surfaces that I touch are cleaned regularly between classes. The law school is set up with one-way hallways. We're tracking COVID cases, and we're not finding that they're originating within the law school. So I feel safe. Everybody's in a mask, teaching from inside a mask. I'm sure we're all getting used to that, and it's kind of I get incredibly thirsty when I'm speaking through a mask. But I have a number of students who, for a variety of reasons, can't be there physically. They may have elderly people within their households and not want to get out and bring and come back into the household, or they may have childcare situations that are just insoluble during COVID. So I've got a cadre of students who are on Zoom too. And it's just been a challenge for me. One thing, to stay in the same place so the camera stays focused on me, because I like to wander. To remember that I've got to repeat a question I get from my live students, so my Zoom students hear it, and vice versa. And I've done more lecturing and less calling on students. And I think that's a loss, and I think that I haven't adapted as well as I should have, because I find it easier, and I find myself doing that. Otherwise, I get so pulled in different directions and distracted. So I jumped in and said I'll start this, but I don't think I have very good solutions.
I've leaned on the tech heavily. I did all remote, one, because I thought hybrid would be too difficult. When I teach UCC, I use a doc viewer to go through the statutes. And, I just could not imagine being physically in a classroom, running my PowerPoint, running the Zoom for the people who are hybrid, and running the doc viewer. Like, that was just a bridge too far. So I chose to just be at home and do it all remotely. And I actually think that UCC classes lend themselves quite well to being taught synchronously or asynchronously online. Because, I use Google Docs and Google Sheets so that they could respond to questions during breakout rooms. So, something that I might normally walk around the room and pose as a Socratic question, I would embed it into a Google Sheet and make sure I popped into breakout rooms instead. And then when we regrouped, I always left time for regrouping. When we regrouped, I would call on groups that I had not visited with. So, if I see 2 groups, I call on the other 2. And I'm able to, I'm able to see in writing what they think. And so in some ways, I think the Google Docs thing is something I might keep even post-COVID, because it forces each group of students to type out their answer and I can see where they're going wrong. The other thing I used a lot, I used Google Docs for group drafting. So, when I tell them find the clause that addresses X, I can upload that into Google Documents and have them revise it. And what I really like about that too is I can see who typed into it and kind of do some, checking up to see if someone's slacking. And so if it's like, why is this person never typed into this document? Did y'all all meet and confer, or what happened? And then lastly, I use discussion boards a lot, via Canvas or whatever platform, to have some of those outside of class discussions that we just run out of time for because of the time it takes to do Zoom.
I haven't taught a class since the advent of COVID and Zoom teaching. I've taught CLE courses for UK. I've taught various client seminars. The one thing that bothers me, I mean, you can bring in outside content. You can bring up like the Secretary of State's website that I talked about. What you can't do is read the faces, because in my 16 years of teaching, I could tell by looking at my class, I need to figure out a different way to explain this one. I need to spend a little more time here. I need to back up a step. And that's lost in the Zoom environment.
Yeah, I agree with that for sure. But I'm with Carlos. I feel like there are some aspects of this that I'm going to keep post-pandemic. And for me, moving my kind of description of what they just read in the text, and I'm thinking mostly about secure transactions right now, moving that and sort of flipping it, having it available to students before they show up in class is something I'm going to stick with, because it really improved the responses to problems. And
I think it was Tom Friedman, the columnist in the New York Times, who said the pandemic has not changed the directions we're going. It's accelerated the pace at which we're getting there. I think that's what's happened in terms of Zoom and teaching.
I agree. So I'm going to look back through the chat, and we have had some questions come in. So why don't I take this one from Martin, because it's the first one I'm looking at. Martin's a law school dean. He's thinking about the future of commercial and corporate law curriculum, and that is his background. So they had full-time faculty teaching 2, 3, 9, and basic contracts, and now there's one faculty member basically handling that entire area. I think we can all relate to this idea. So what are the subjects, especially thinking about these technological developments, for which a school should cultivate, oh no, I lost it, a tenured and tenure track scholar versus allowing adjuncts to teach? So which are the core doctrinal faculty classes, and which we bring in the experts from the field?
Bill, you want to take a shot at that one?
Thanks. It's a great question. I'm slightly stumped, because I think good adjuncts, really can fill any of these roles. John, there's nothing I like more than teasing John McGarvey, but John is as knowledgeable and able to communicate this content as anybody I know in academia, and better than myself and better than most. But I do think that probably your basic Article 9 course should be taught, and your basic payment systems course should be taught by full-time faculty members. I think there's a huge need for more specialized courses. For example, I really want to teach an advanced Article 9 course that gets into particular types of transactions, loan participations, securitizations.
Oh gosh, yes.
You know, and for that, I really think an adjunct is going to do a whole lot better job than I am, because they're going to be able to bring all the documentation and put the different areas of law together. I mean, to do a securitization, you need to know some tax law, securities law, entity law, right?
Yeah.
So I think kind of the basic courses, my thought is that most schools should have a really competent across the board law school should have a full-time faculty member teaching those courses, even if they use adjuncts for some sections. But that law schools ought to think more strategically or more broadly about specialized courses. And there's tons of stuff in the international arena that we can't get near today for lack of time that we ought to be doing with regard to these courses.
Well, Bill, in terms of developing new full-time faculty members in areas, what you're working on, and I am to some extent, amending the UCC to accommodate emerging technologies, that's a wide open field right now.
Absolutely.
I think just, you know, hiring a commercial law person who's a commercial law person in and of itself would be a good start. You know, I actually teach BA and teach corporate law in addition to commercial, and I straddle both sides. But, you know, I think, you know, and that's kind of just, you know, out of the nature of who's on a faculty and who has the capacity. I know a lot of people who teach commercial law also are teaching basic BA. And, you know, it's difficult to cover everything if you only have one person or only two people who are expected to straddle both sides. So, you know, the idea of having, you know, I think every faculty needs a standalone commercial law person. And maybe it's commercial law plus bankruptcy, or maybe, you know, it's commercial law plus tech. But, you know, if you look at faculty rosters, there just aren't many that have a pure commercial law person anymore. And, you know, and I think because of that, you know, to get into what Bill said, because you don't have someone who is writing about commercial law on your faculty, you're missing the opportunity for students to take a seminar. You're missing the opportunity for students to get that drafting class. And while, you know, I think it's awesome to also have the adjuncts doing it, there needs to be someone who sits in a faculty meeting and makes decisions, who has that experience and that knowledge to say when an adjunct is needed or not.
Carlos, I agree with you and Bill on that. You know, I taught as an adjunct. My whole teaching career, I was the adjunct, and there were usually two full-time tenured professors who sat in those meetings and taught the same subject I did in different sections during the year.
And now I would say most faculties probably have one, or, you know, sometimes the faculty has no one who's a dedicated commercial law person.
Absolutely. Comment in the chat came up, you know, when you're thinking about finding a commercial law faculty, often there's not a lot of people writing about Articles 3 and 4 and 5. So we've got our Article 9 faculty and bankruptcy, which of course brings in those concepts. I saw a question way back when that we didn't get to early, so I want to find that again. It was from Carl, and it looks like it's for you, Ben. So when you're thinking, or Bill, sorry, when you're thinking about being tech neutral, should you think about the term transfer? Is transfer itself a tech neutral word when you're dealing with new technology?
Well, yeah, I guess it's used in a lot of different contexts. Transfer, you know, I talked about that wrongly decided UCC case that used assignment, and there's a PEB commentary, I think it was 21, but that also deals with transfer, because Article 9 uses assignment and transfer and doesn't define them. So I use, you know, you get into the distinction between whether we have a voluntary I want to use transfer in my example, a voluntary movement of rights from one party to another, or an involuntary. We have purchaser for anyone who acquires in the UCC, for anyone who acquires property rights through a voluntary transaction, so the donee is a purchaser. Although we only protect purchasers for value, so donees don't get anything out of being within that definition, but we use them in such technical ways, and I don't know that we use transfer as technically as we should, and I've seen it used in lots of different contexts. I mean, you have a transfer in Article 3 as opposed to a negotiation, right? You don't have a negotiation, but you have a voluntary transfer of an instrument which transfers to the transferee the rights of the transferor, if that was the intent of the transaction. So it's a good question, and I'm bumbling and stumbling in my answer. It's used all over the place, and I don't know that there's a single useful definition.
Just so it shows the pain of adapting and modernizing. It really, you really do have to break a lot of chains, including to the dictionary.
Oh, absolutely. We've got to have the right terminology, and we've got to define it the right way. I mean, you look at Article 2, and how is it possible that the Battle of the Forms is spawning case after case after case 60, 70, 80 years after it was drafted? And it's because we have all these undefined terms floating around in there.
And we've been unable to reach a consensus on a redraft of Article 2.
Don't remind me.
One day, perhaps. Well, I think I got all the questions in the chats. I saw a lot of amens for the idea of more payment systems and 6-hour contracts. So I think we have a friendly audience for our ideas here. So unless I see something pop up, and please somebody retype or repost if I missed it in the conversation, how about we go around and just kind of give our final thoughts on bridging this gap, teaching commercial law in the 21st century. Bill, you want to start?
Yeah, I think it's the same as teaching commercial law in the 20th century. I think Carlos made a really great point right at the outset of this, talking about core principles. And I think there are core commercial law principles that are applied in different contexts. And you can apply them to 18th, 19th, 20th century milieu, or the 21st century milieu. But I think we need to sort of demystify this and not get so hung up in our need to. It would be great if we all could understand the technology. That's not going to happen for me. But I need to be able to apply these concepts within the framework of that technology and understand what's going on, and be able to transmit that, to either transmit it to the students, or maybe I should say transfer it to the students, or give them exercises where they can get themselves up to speed with it. So I don't think it's really different. We have different tools at our disposal. We need to make use of those fabulous teaching tools. But if we get too hung up on the whiz bang of it, then we lose the core of it.
Fair enough. Carlos, you want to go next?
Yeah, I think that the most important change and the biggest difference is for us not to get bogged down by the bar exam and forget that all of these courses are important for teaching fundamentals. And so as you are cutting these commercial classes from the curriculum, they're just skills that your students could be losing, because I think everyone who teaches commercial law naturally folds in documents when they're teaching payment systems or Article 9, and they're naturally teaching both statutory interpretation and contract interpretation, and to the point that we often don't talk about it amongst ourselves because it's just so inherent in what it is that we're doing. And even teaching problem-based, I think commercial law is one of the first areas to truly adopt problem-based learning and application. That is something that gets missing from your curriculum overall when you drop these classes. So, I think going into the 21st century, it's important to remember, even though we might have skipped it in law school like I did, now that I teach it, I can see what I missed. because I was so focused on I can teach myself that for the bar.
John, any final parting words?
Well, I'll go back to something I said early on. One of the essential purposes of the Uniform Commercial Code is to facilitate commerce. And as technology changes to facilitate commerce, the Uniform Commercial Code has to change. We did it I won't say really in reaction to, but the last substantial amendments to Article 9 were the 2010 amendments. Part of that was, a good part of it was to clarify the issue on individual names. How did that come up? It came up because secretaries of state went to computerized search systems, and you didn't have the fuzzy logic of going through pieces of paper in a drawer to find a name. You had to have an exact match. So we adapted for that. Now we've got new emerging technologies. And one of the things that we have to do as drafters is attempt to draft with durability to the best we can. So it'll last 10 years, 20 years, 30 years until we need to do the next set of amendments. But yes, we need to teach commercial law not as it existed 20 years ago, not as it existed 10 years ago, but as it exists today and as it's going to exist as these students go out in the real world and start practicing law. But I'm really glad to see this offering today as part of this session, because I hope we've added some emphasis to the importance of teaching commercial law. And yes, it is important to have constitutional law scholars and tort scholars and evidence scholars and criminal law scholars, but the economy depends on commercial law and law students having a good background in it to advise their clients on how to make business work.
I like it. That seems, we've got a couple more minutes if anybody has a final question or final thoughts, but if I don't hear anything in the next minute or so, we can send people on their way a little bit early. And I just want to thank you all. I learned a lot from this panel. It's gotten me jazzed to get ready for next semester, which I have to say is a feat given existing limitations. So thank you so much for your time and your ideas. And thank you again to our sponsoring organizations. This was a great panel to put together. And to spend time talking about. So thanks.
I appreciate the opportunity to work with all of you.
Yeah, thanks for including me.
Yeah, this was fun. Thank you. Thank you, Kara.
Thank you. Thank the organization.